The following program is for informational and educational purposes only and is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to Fraudsters Radio. I am Laurie Z, your co-host, a consumer advocate, along with my co-host Storm Bradford, the owner of Mortgage Fraud Examiners. And Storm, how are you doing today?
I'm fine, thank you. How about you, Laurie?
I'm doing pretty good. What would you, before we get into our guest, what would you like to speak about?
Well, I guess we can talk a little bit about our guest that's coming on shortly and some facts and figures of what's going on in the foreclosure defense world today. And it's fairly obvious now, at least to us, from the research that we've done and others, that the foreclosures are beginning to tick back up again. They had a dramatic increase in July, and it appears as though it's going to continue to be that way at least until the end of the year.
Okay, so when you talk about dramatic increase, are you speaking about specific states or the country as a whole?
Well, there's some specific states, but basically in the what we used to call the foreclosure capitals, like Florida, Arizona, Nevada, Illinois, New York, New Jersey, that's where you're beginning to see them tick back up.
All right. Now, are they kicking back up because it's the loan modification end of period, and now it's going back up, or is it just starting over again completely?
Well, I think what's happening is a lot of these HELOCs are coming to an end. A lot of these loan modifications that were 5-year loan modifications, where they're going to go back up to what the loan originally was, they're coming to an end. So there's a lot of reasons for it to tick up. Also, too, because some of the weather problems that we've had. But as a rule, those states that used to be the foreclosure capitals are basically continuing to be those.
Yeah, it's a little bit scary. And I'll tell you, I'm a credit consultant, so I work with the clients of a lot of mortgage people. And what I'm finding from the mortgage people is that the programs they offer are relaxing again, down to, say, a 580 mid-score to qualify for a house. And that's kind of how the last bubble started. When you relax those standards and make it such a risky loan, it's gonna start again. Do you think?
Well, actually, that's not what caused it. What caused it was two things. One was the amount of appraisal fraud, which in these foreclosure capitals, we find appraisal fraud as much as 90% of the time. And what really caused the downfall is they were over-appraising these properties. People got into loans where they had 1% interest loans or interest-only loans, or some ARM that after a few years was going to go back to what the normal rate would be. But what was happening was because of the bust, these houses that were overappraised were now, people couldn't, because they're underwater now, people couldn't refinance out of that loan into the new loan, which they thought they'd be able to do if the appraisals kept on going up, which they stopped. And part of the problem also as well, because of a tremendous amount of these liars loans, these homeowners were going into foreclosure, so that was bringing the property values down. And again, someone that thought, well, hey, I'll just do this for 3 or 4 years. The market keeps going up. I'm going to go ahead and just refinance into a different loan. Well, that day never came because their house was now underwater. But that was the major cause of what caused it all.
Right, and I think that, you and I talked a long time ago, it'll take years before the market ever rebounds to where a lot of these houses were actually purchased. I mean, it may have gone up a little, but it hasn't, recouped or evened out to where it was beforehand.
Some places it has, but as a rule, you're correct. The majority of places, no. A lot of these homes are still underwater.
Okay. So what do you think is coming up on the horizon for some of these banks? Like I read recently that Ocwen was in trouble, and they had been fined, but I guess the money doesn't, if it goes to the Consumer Financial Protection Bureau, it doesn't actually help any of the homeowners.
Well, that's true. I mean, none of these settlements or anything ever helped the homeowner. They just they got sanctioned for not doing things properly, not so much that they were committing fraud, it's just that they were just not doing things properly. Again, the majority of these foreclosures are because the homeowner breached the contract. They're not making the payment.
Right.
So, you can't blame the bank for, you have somebody that's had a loan for 5 or 10 years and they're paying on the loan for 5 or 10 years. There's never been a problem. And then all of a sudden they either listen to a bunch of scammers that convinced them of something where they stopped making payments, or maybe they lost their job for a while, or, there could be a lot of reasons why they breached their contract. But the bank is doing what the homeowner agreed they could do, is to take their house if they fail to make timely payments.
Right. Now, what you do at Mortgage Fraud Examiners is a legal transaction of all their closing documents. So I do know there are times when there are situations where the houses were overappraised or there was some type of fraudulent inducement. So there are exceptions to those rules. Now, when you have an appraiser that's overappraised, isn't he considered an agent of the bank? And does the bank have any liability, or they have none at all?
Well, they really have a liability because in the underwriting department, they have appraisers that were supposed to look at the valuation. The appraisal was done by the outside appraiser. But what was happening for a long period of time, especially in that decade of 2000 to 2010, they were just trying to get these loans out the door. And they weren't doing their job. And, it makes them liable for that very reason. That's why in the case versus Quicken Loans versus Brown, Ms. Brown got $3.6 million in their lawsuit against Quicken Loans, and I believe it was either $600,000 or $700,000 in a settlement with the appraiser for overappraising her home.
How come there weren't more appraisers that got in trouble? Because, back in the time when the houses were overappraising, a lot of it was pressure from the realtors, so they would get higher commission, for example. How come none of those people really seem to end up in trouble? I mean, you might read about a few here and there, but there had to be a tremendous amount of overappraisals, and yet nothing seems to happen to the appraisers.
Well, how could a homeowner know their house was overappraised if they didn't have their transaction analyzed?
Okay, that's true. That's true.
Why
All right,
analysis of the mortgage transaction is so important, because that's where you find out if there's any wrongdoing in your mortgage transaction. I mean, you're just not going to find it any other way unless you analyze that transaction.
Gotcha. Well, we're going to have a guest on shortly who's another consumer advocate to talk about some things going on with an attorney who ended up in a lot of trouble. We're going to talk about that in a little bit. But maybe before Bob comes on, you and I can talk a little bit about that, because you had a lot of attorneys that just caused additional harm when they, said they would represent clients. Well, the word foreclosure defense, nowhere in there does it say offensive action. It says foreclosure defense. And so people didn't realize that, and they were, in reality, not realizing that they were really never going to win. They were just going to pay these attorneys a hell of a lot of money to keep them in their house, sometimes as much as the mortgage payment, right?
Well, I'm going to start off by defending the attorneys, and then I'm going to end up by crucifying the attorneys.
Okay.
In their defense, they don't know how to analyze a mortgage transaction because they don't know how banks underwrite loans. They don't know the inner workings of banks. They wouldn't know how to analyze an appraisal if it jumped up and bit them in the behind. That's in their defense. Now, to crucify them is because what they were doing was, unbeknownst to a homeowner, they're in foreclosure. The first thing that hits their mind is, hey, maybe I better get an attorney. They go find one of these, what we call pretender defenders or stall attorneys, and say, hey, look, I'm in foreclosure. Can you help me? Oh, yes, I can help you. Okay, what's it going to cost? Well, you can give us $2,500 up front and $1,000 a month, and we'll work on this thing for you. They never told them that they were going to save their house. They just said they'd work on their case for them. That's why these homeowners need to read their retainer agreements that they had with these lawyers, because the lawyers are not about to say in the retainer agreement that they're going to do nothing but stall, because that is an ethics violation. Just stalling a court case is an ethics violation. So you won't find them saying that. What they would do, or they might do, is say, well, look, all we can really do is stall, and that's what they tell them verbally, but when they get the contract, there's no verbiage in there like that. Their retainer agreement would say that. So that was the honest ones. The majority of them just wouldn't say anything. They'd say, look, we'll just work on your case. Well, in places like Florida and judicial states, if a homeowner from the very first time they miss their very first payment to when they get thrown out of their house, it's a minimum of 3 years if they did nothing. So you had these attorneys who would file these, would wait, take their case, wait and, file an answer maybe, and then wait until it wound its way through the court system where it would come to trial, and then it would come to trial, and the bank would take their house because the homeowner agreed they could. Or in the off chance that that they didn't have the note when they actually filed the complaint, there's specific laws, especially like Florida, that says if you didn't have the note when you filed the complaint, that wasn't permissible. You had to do it. So the judge would say, sorry, bank, I'm going to dismiss the case. And if you want to foreclose on this person, you better have the note attached to the complaint when you file it. You didn't this time. The law said that you had to. The rule said you had to. You didn't do it. So I'm dismissing the case. Well, before the ink is even dry on that judge's order, because the bank now has the note, they're down in the clerk's office refiling the lawsuit. And then when the homeowner comes back, what's their argument now? They don't have one, and they lose their homes because they never had their transaction analyzed.
Well, what concerns me as a consumer is that how can these attorneys, is there specific training for being a foreclosure? It seemed like everyone jumped on the bandwagon, especially a lot of bankruptcy attorneys. Is there a specific type of training or classes that foreclosure defense attorneys have to take, or can anybody be a foreclosure defense attorney that's a lawyer?
Well, you could hold yourself out as anything. You could hold yourself out as a defense attorney in homicide cases. But if you've never tried one or won one, I wouldn't want you as an attorney.
Right.
So same thing with these foreclosures. The poor homeowner doesn't know what questions to ask, and that's why we tell homeowners all the time, I don't care if it's a foreclosure or a traffic ticket or a felony or whatever the case may be, is first question out of that individual's mouth before they hire the attorney is, how many of these cases have you done? And the second case is, how many of these cases have you won? If the answer is none to both, you need to grab your purse and run out the door.
Right. I think that's what happened a lot when I used to get clients that would call, and I would say, well, did you ask the attorney how many cases they've won, and they would say, well, what do you mean? I go, you need to know how many they won. Otherwise, you're just paying them, to stay in the house, and eventually it's going to foreclose. Well, you know what? Let's do this, Storm. Let's go to a short commercial break, and when we come back, we should have Bob Hurt, consumer advocate, on the line with us. Stay with us.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
Welcome back to AM/FM 24/7 radio. And we have a special guest today, Mr. Bob Hurt, who is a consumer advocate down in Tampa, Florida, as our guest today. Bob, you online?
I'm on.
How you doing?
Hi, Bob.
I'm doing great. Well, it's good to hear your voices.
Yes.
It'd be nice to see you in person out on the beach.
Yes.
Lollygagging around in the sunshine under the beautiful, clear blue Florida skies.
Well, Bob, why don't you start off by telling us a little bit about your background and your websites and how people may be able to contact you?
Oh, well, my background is, after some years in the Navy, I went to work for some computer companies and spent my entire adult life in the computer industry. I retired from that in 2002, decided to start studying tax code, and I got tired of that after a few years and started studying foreclosures. So I conducted some seminars, 2008, 2007, and decided as a consequence of those that foreclosure defense is not going to work, because the best that can happen is a person will temporarily stop the attack, and then the creditor is going to come right back and hammer them and win. So I actually called up Storm Bradford, a noted mortgage examiner, and asked him if he'd come down and help me with a seminar. And instead, I stopped doing seminars and built the mortgageattack.com website, the purpose of which is to inform people about the uselessness of making certain frivolous arguments in foreclosure defense and the vital importance of getting the loan examined by a competent professional so as to find out how the borrower got injured and then to either negotiate a settlement or to go on the attack in court against the injurious parties. So that's what I've been doing since 2009. And so I'm still doing it. I guess you could call me a consumer advocate or a maven of mortgage attack methodology. And that's how I spend my spare time, and almost all my time is spare.
Well, let me ask you, how do you know that examining the mortgage transaction and attacking that contract is the only methodology that works? How do you know that?
Well, the borrower stops making his payments. He agreed in a contract, the mortgage or the deed of trust, and a note through which he borrowed money to buy a house or to refinance it or whatever. He agreed that he would do certain things, and the number one thing he needed to do was to make his mortgage payments on time. Make full mortgage payments, not a penny short and not a second late, according to a monthly schedule, typically. And if he fails to do that, he breached the contract. So what does a person do who breaches a contract? No, in the old days, a borrower who found out he just couldn't make those payments because he lost his job or had a serious health problem or something else come up, most of the time they'd move in with a relative or a friend, garage sale their stuff that they didn't need, and hand over the keys to the creditor. To these days, ever since wise guys got involved in the so-called foreclosure defense industry, in other words, foreclosure pretender defender attorneys, ever since those guys started trying to make a name for themselves, borrowers think that, well, if they didn't make mortgage payments, maybe some lawyer will get them out of it. And all the lawyer does is buck against things like the wrong party tried to foreclose or he didn't fulfill the conditions he was needed to before foreclosing. And all that did was result in a temporary halt to the foreclosure process, and eventually the right creditor will come along, correct his errors, and go ahead and foreclose, and this time he takes the house. Or in other words, the court orders a sale of the property, or in a non-judicial foreclosure state, the trustee orders a sale of the property. And that money brought from the sale goes to pay off the debt. Sometimes the borrower is left with a deficiency, especially when there was a downturn in the value of houses, and that deficiency becomes something that you can only cure through years of paying off or through some kind of bankruptcy. Well, that is the only thing a person can do unless he tries to discover that somehow in the making of his contract with a creditor, somebody injured him. Now, if the contract was unconscionable, in other words, only an idiot would have signed it, their terms were that bad, or if he got baited and switched, in other words, they promised him, the mortgage broker promised him certain terms and gave him worse terms, like a higher interest rate, or if the appraiser lied and said the house was worth a whole lot of money and it was only worth half of that, and such things have happened. In cases like that, or if there were various regulations or regulatory laws that were violated having to do with mortgages, such as the Truth in Lending Act, or laws violated in collecting the debt, well, all of these things that could have happened to him, and there could have been numerous of them, will justify his putting up a fight in court. And because the people who injured him know this, if he finds out how they injured him, and then he calls them up and talks to them about it, usually they'll work out some kind of settlement because they know that if he takes them to court and sues them, even though he's in foreclosure, if he countersues them or cross-sues them, they're going to lose. And since they're going to lose, they might end up having to pay his legal fees as well as their own, and definitely they're going to have to pay him a damages judgment. So they would be idiots to let him go forth with his lawsuit, and they do their best to dissuade him, and the only way to dissuade him is to make a deal with him and say, look, tell you what, if suppose a creditor hurt him, tell you what, why don't we reduce the amount of money you owe us and give you credit for your paid-in equity and reduce the interest rate down to something reasonable like 4% these days. That would be a reasonable interest. And when we kickstart your loan for 30 years, your payments will go down. You'll be able to make them now. So how would you like that? He might say, well, just fine. I'd like that. That solves his problem. Now he's back in good stead, and he's in the black again, and he can make these mortgage payments, and he won't get in trouble. But so many of them get hoodwinked into doing things like a loan modification that just simply piles an enormous amount of debt for all of his accrued interest and so forth on the end of the loan and sticks him with a big balloon payment, and the interest rate will go back up in 4 or 5 years. It's going to be terrible, and he will probably get foreclosed on again because he won't be able to make those big payments. So your question was, how do you know? The point is that we know that a mortgage is a contract. And when somebody violates the contract, like the borrower, by failing to make payments, the other party is going to come after him and enforce whatever relief and remedy is available in the contract. But by the same token, the borrower can do a similar thing. The problem is that the foreclosure defense industry never bothers telling the borrower this, because the lawyers who run it, they make their money by pretending to defend against the foreclosure, and they don't have the skill or the knowledge to actually examine all of the elements of a loan transaction and find out exactly how the borrower got injured. Furthermore, it would cost them so much money, cost them, 50, 60 hours to do this work. They're not going to bother with that work because the borrower, who's in trouble for not being able to make payments, doesn't have enough money to pay them to $15,000, $20,000 to examine their loan transaction. So they don't bother doing it. And as a result, even though they hold themselves out as legal experts, they never even suggest to the borrower he has this potential, and as a result, they engage in legal malpractice. Because as a legal expert, they should never take a case unless they're going to do a proper job for the borrower. So an entire industry has been established called the foreclosure defense industry, which I call pretense defense, because the entire industry is made up of crooks like Mark Stopa, who just got disbarred for being a crook, who ran a foreclosure defense industry for years without actually suffering any severe punishment. He's never been accused of legal malpractice that I know of. Nobody sued him for that, though he should have been sued many times for it. Why? Because borrowers can't afford it. So you've got a breach of contract issue, and the breach of contract hatchet chops both directions. It not only chops the borrower, but it also chops the creditor and other people involved in it if they did crooked things.
Well, Bob, I know Laurie's dying to jump in here, but we only got a couple minutes before we go to a commercial break. But I just had one more question for you is, what is the failure rate of people who don't get their mortgage transaction analyzed, and what is the success rate of the homeowners that do get their transaction analyzed?
Well, the people that don't get their mortgage examined and analyzed for causes of action against the creditor, the lender, the servicer, the title company, the mortgage broker, or the appraiser is, I would say, probably about 98%. Some of them manage to do a short sale or a deed in lieu of foreclosure, but the vast majority of them lose the house through an ordered foreclosure sale. And even if they do a keys for cash or a short sale, they're still losing the house. So the vast majority of them lose the house. Of the ones who get their...
I was just saying that's assuming they didn't get a loan mod.
Well, yeah, if they didn't get a loan mod, and the vast majority of them don't qualify for a loan mod, and the bank doesn't want to give it to them anyway. They have to offer it, but very seldom do they give it. So the other alternative is getting a mortgage examined. The people who do that, and I would guess that somewhere around 95% of them have some cause of action, justification of suing somebody that hurt them in the loan process. Most of them settle out of court. And the few that go on the attack, if they do it artfully, they always win because they have been injured and the courts want to compensate them for their injury. In other words, there are a lot of people who go into a foreclosure defense battle and claim that the judges are crooked because they always rule in favor of the bank. Well, you can't blame a judge for ruling in favor of the bank when the borrower breached the contract. The bank's got to get his relief. But if the borrower can prove that somebody injured him, including the creditor in the loan transaction, then the court could offer order a set-off from the debt based on the amount of the injury, or some people get their house free and clear. We know a case in Brown versus Quicken Loans case in which the woman got, with a $46,000 house that Quicken Loans appraiser had appraised at $144,000. She got a $2.1 million punitive damage award, and her lawyer got a settlement from the appraiser out of court for $700,000. I'd say that's a pretty good win for going on the attack.
Well, actually, the total award was $3.6 million to Brown, and the $700,000 settlement with the appraisal firm.
Yeah,
right. And I'm going to ask you guys to hold your thoughts just for a second. We're going to go to a commercial break, and Bobby can continue as soon as we come back. We'll be back in just a moment. And if you'd like to call in and ask a question, the number 646-668-8512. Stay with us.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first. Identify errors that would void the contract. Identify regulatory violations. Identify appraisal fraud and other fraudulent contact. And the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
Here we are back on AM/FM 24/7 radio with our special guest, Bob Hurt, a consumer advocate in Tampa, Florida. And Bob was just explaining to us and the listeners about the difference between attacking and not attacking a mortgage transaction. So, Bob, what you were saying basically was, if I understand you correctly, is that the numbers are about the same, but they're total opposites. The failure rate is 95% and upwards for not getting the transaction analyzed, and it's 95% success rate or upwards if they do. Has that been your experience?
Yeah, that's pretty well. It's hard to judge exactly because a lot of people don't report back what happened in their situation. They win and they never call up and say, "Hey, thanks a lot." But let me point out that there's a very important thing for borrowers to think about. First of all, it makes sense to get a mortgage examination done even if you're not in foreclosure. And I would say especially if you're not in foreclosure, because people that aren't facing foreclosure can more easily afford a mortgage examination than people who are in foreclosure and can't make house payments. So the time to get a mortgage examination done is before you start facing difficulty making payments, because you could just as easily find that there are numerous causes of action available to you to justify suing, and you can still get a settlement and get the money knocked off your loan by doing this in advance of, the disaster of foreclosure. So that's one point. The second point is that if you do face foreclosure and you think about hiring a foreclosure defense attorney, think again. That is not a wise strategy. Let me give you an example of why. Just recently, in Florida, there has been a long-time foreclosure defense attorney named Mark Stopa, who, that's spelled S-T-O-P-A, who had a business based on foreclosure pretense defense. And he had so many complaints against him from people that he cheated, his own clients, and from his misbehavior and bad conduct that the Supreme Court of Florida ordered his suspension of his bar license. In other words, he's not licensed to practice law. So what happened is another lawyer named Richard Mockler set up a company called Stay in Your Home, or Stay in My Home, and has offered all of Stopa's clients to take over for him. Well, how can a foreclosure defense attorney let borrowers stay in their home when all they can do is defend against things like the wrong creditor filed for foreclosure or they didn't fulfill conditions preceding? There's no other way to keep people in their home other than trying to sell them a loan mod. And you don't need a lawyer to buy a loan modification. So that is just a scam. Well, here's what happened. I have published both on the mortgageattack.com website, on livinglivesthetruth.com website, the story about Mark Stopa's disbarment. And anybody who has an interest in this should go there and read, because Stopa got caught for doing these things, but there are many attorneys doing similar things who haven't been caught yet. And in fact, if more of the foreclosure defense victims were to file bar complaints against the attorneys for failing to examine their mortgages, failing to inform them that they should do, for taking their cases when they never should have taken them because they knew they couldn't do a proper job on them, then we wouldn't have such a plague as exists now. The problem is that people who get a mortgage examination done, they still have a hard time going to an attorney and expecting that attorney, that foreclosure defense attorney, to do a proper job. Many of them will refuse to lodge the causes of action against the perpetrators of injuries, because if they did that, then all their other clients would hear about it and would wonder, why didn't you do that for me? And they would come after them and try to torture them over it.
Yep. Now, Bob and Storm, we have a caller, Frank. Frank, are you on the line?
Oh, yes, I am.
And did you have a question that you'd like to ask?
Yeah, I have a problem with a lender.
Okay, why don't you tell us what's happening?
Well, I've been getting notices from the lender that they're going to foreclose. I had made payments, but I decided to stop making payments because everything was so screwed up. I don't know what they're doing with the money. And now they're threatening to take back the house.
Well, Frank, let me stop you for 1 second. The worst mistake you can make is to not make your payment. Because when you stop making that payment, that's when you breach the contract. And by contract, you said the bank can take your house. So just because you think there may be something wrong or some scammer has given you some argument that is not factually or legally correct, your best bet is to make sure you make that payment. And if you only missed one or two, is make those payments, get back current, because there's all kinds of things you can do to discuss with the lender, but you have got to make that payment so you don't breach that contract and put yourself in harm's way.
Well, but I've made the payments, and what they do is that I send the payment out on the 1st, and somehow they don't show that it gets there till like the 17th or 18th, and
the payment is supposed to be there. Excuse me, Frank. The payment is supposed to be there by close of business on the 1st. You can't send it out on the 1st. It has to be in their hands by the 1st.
So mine says that. Yeah, mine says the 1st, but it's late on the 15th.
Well,
they can charge a fee after the 15th, and they seem to hold the check.
Yeah, but you got to understand that. Don't misinterpret what that's saying. All that's saying is that if you don't make your payment by the 1st, that we're going to hit you with this late fee. It doesn't
on the 15th. If it doesn't get there by the 15th.
It doesn't take 2 weeks for a check to get somewhere, right? Somebody's holding a check.
But it's supposed
so they're saying, I do that with my homeowners. They say it has to get there by the 31st, so I make sure I send everything out on the 1st. Everybody gets everything. The homeowners get it about 3 days later. These guys, as Wells Fargo, they should get it too.
Well, let me give you some real life examples. I had a friend of mine who basically did what you did, and he would send his payment out on the 1st, and he said, well, it's probably going to get there before the 15th, so I won't get hit with that late fee. And he was right. It would always get there prior to the 15th. He did that for probably 4 or 5 years. He went back to refinance his loan. They wouldn't let him refinance the loan because they said that you never made your payments on time. On time means the 1st by close of business. So technically, when that payment didn't get there by close of business on the 1st, you breached the contract. So, yeah, it has got to be there by the 1st, not by the 15th. All they're telling you is that if it's not there by the 15th, we're going to hit you with a late penalty. But that doesn't give you abstention from making sure it's there on the 1st. It's supposed to be there on the 1st. It says on the 1st. It says it's not to be paid by the 15th. It says to be paid by the 1st.
So, Storm, let me ask you a question. I'm going to kind of butt in based on what he said. So if someone's mailing out their mortgage payment due by a specific date, and there have been plenty of cases where the banks have held the check to the late payment, maybe it's a good idea, and it's sad that you have to do this, but send the check out, certified return receipt mail, so someone actually has to sign for it and to prove that it was actually delivered, because it doesn't take 17 days for a piece of mail to make it anywhere in the United States, really.
Yeah, but
I've tried that, but they don't accept it. That's and then they don't know who signed for it. I mean, it's
they got to accept. See, here's the thing, Frank.
You would think, but they've actually said that they've opened the package and the check wasn't in there.
Yeah, here's where you get them, Frank.
I'm dealing with some real crooks at this Wells Fargo. I mean, this is.
Oh yeah. Well, here's your thing.
I'm hearing things that I've never heard before. They're saying I didn't put the check in there. Yeah, they got the package. I mean, they're pulling everything there is. But so what I did is I'm sending the money to, and I open up an account at Wells Fargo, and I'm sending the money there and showing them that it's there. And then I told them, hey, I owe more than the house is worth. Why don't you just take the house then?
Well, Frank, you did something very smart. You said, hey, I think they're playing games with him. So what I'm going to do is, hey, wise guys, I'm opening up an account at your bank, and so they can't come back and do it. But as a rule, like I was saying, that payment has to be there by the 1st by close of business. Let me give you another example. I know a guy who, what he did is he did second trusts. People would come to him and borrow money. He would lend them money on a loan like similar to a HELOC or something, but it was second trust loans. And he used to do that. And I was in this guy's office one day, and I heard the conversation with him on the phone, and I can hear the guy on the other end of the phone screaming. And I hear him saying, look, you understood what the deal was. The payment was supposed to be here by the 1st, not the 2nd, the 1st. He said, I'm foreclosing on this house. And when he got off the phone with the guy, I said to him, I said, my God, I said, why did you do that to that poor guy? He says, look, he says, I'm in the business of loaning money to people. He says, I want everybody to know that the payment is due here on the 1st. And if it's not on the 1st, I'm going to foreclose on you. That's what I want people to know. So when they come to me to borrow money, they know that if it's not here on the 1st, they're getting foreclosed on. And
well, I have something even better for them. I have a HELOC with Wells Fargo also, and if they want to threaten to foreclose, they can go ahead and foreclose, and then they can make the payment and service the 1st. I believe that's the way it has to go. That the 2nd, if they take the house back and it doesn't have any equity, they're still going to have to make payments on the 1st, and then I'm going to let them get it there on the 1st.
Yeah, but they're still going to make out because see, they can buy a foreclosed note or a non-performing note for 35 to 50 cents on the dollar, so they're still going to make out.
Well, they're going to lose all the they're going to lose all the money on the HELOC because there's not enough equity in the house to cover it. So I don't see how they have any strength. I heard this, and I might be wrong. I heard this 1,000 years ago. That when you get a mortgage and they give you $400,000, if they lend you $10, they got you by the cojones. When they give you $400,000 and your house is worth $300,000, the people I've talked to said I kind of got them by the cojones. Maybe I'm wrong.
They're not going to lend you $400,000 on a $300,000 appraisal.
They did. They did. This is a 10-year-old loan. They did.
No. They gave it to you when the house was worth that. It may be not worth that today, but it was worth that at the time.
Exactly.
Or they wouldn't have given you the loan. But still, not only do we do these exams for homeowners, we do them for pension funds and hedge funds that buy these.
I understand, but see, they're holding a piece of paper, and I had the $400,000. So I don't see how they control the situation. But then again, I called you for advice. I don't mean to give you advice, but I understand that you made it clear the 1st is the 1st, and I guess that's the problem. I'll try to resolve that with them, and I really do appreciate your.
Frank, you were very smart about it. You solved the problem. You just walk into Wells Fargo Bank and say, hey, guys, I've been having problems with you not accepting my payments on time. Here it is. It's before 5 o'clock on the 1st. Here's your money.
Well, I don't do it too well. I kind of lost my temper, and I call the women all kinds of names. So I'm too embarrassed to go in there, and I don't think they're going to let me in. But I'll work it out with them. I really appreciate your help. Your advice is very good. That if it really is due on the 1st, then I guess I am wrong getting it there. Mailing it on the 1st.
Well, it doesn't make you wrong. It's just a lot of people believe that. They think they can do that, but that's not how the contract's written.
Well, I appreciate that. That's something I didn't know, and never too old to learn. Thank you very, very much. Great show. I enjoyed listening to the show.
I enjoy your day.
Thank you.
Okay. Thank you, guys.
Too.
Thank you. Bye.
Bye-bye. Oh, I want to kind of jump in here before you guys do, because I've been listening to Bob talk. I want to bring up a few points, and even with this fella, the banks told the homeowners to stop making payments. And so as soon as they did that, their credit dropped 100 to 200 points. So how would you possibly be able to refinance? That was one of my points. The other point, Bob, we're talking about the pretender defenders and storm noses. In the years of the housing bubble following that, I'm going to tell you I contacted probably close to 200 attorneys, either email or phone calls or letters, looking for someone for my clients that would be offensive, that would counterclaim. And all I heard was from lawyers, I don't want to litigate. I really don't want to go to court. I just want to file the pleadings And I'm sitting here thinking every single attorney's telling this. One attorney even offered to pay me for leads, which I know is totally illegal, but none of them actually wanted to do anything when it came to any type of counterclaim or offensive action. They just weren't interested. And I found that to be very disturbing.
Well, see, part of the problem, Laurie, or not part of the problem, but part of the solution was for you, is you knew what questions to ask. The majority of homeowners don't. You got to remember something. This is a known medical fact, is that the logic center of people's brains shut down when they're under stress and they're afraid. Right. It's known medically.
Know that.
So here you have people that aren't thinking clearly, and they go to some attorney, and they don't know what questions to ask. They just want some relief. So they go to this guy. The guy hits them up for some money. And, again, it goes on and on and on for months and years in most instances.
It does, but the homeowner now is injured basically by the attorney. The attorney led them to believe that they were going to help them. The homeowner's version of help is, you're going to try to win my case, when in reality that was never what the attorney intended to do. And, I'm not an attorney, but when people would call me regarding their credit issues, that was a hot topic for many years. And I would give them a list of questions to ask the attorneys because they didn't know what to ask. They just assumed that because they're hiring an attorney, they're paying all this money, they have a chance of winning their house. And the attorney is not telling them that they're going to try to win the house. They're not telling them at all, but they're not telling them anything. They're just not saying anything. And that's untruthful.
Correct. And look at the facts here for a second. There's been 10 million foreclosures, okay? The Federal Deposit Insurance Corporation, they went out and they analyzed a couple hundred or so transactions, and they found that 83% of the mortgages were problematic and 76% of the appraisals were problematic. Okay. Based on those figures, and I'm bad at math, but it would appear to me that the percentage of there being something wrong with that transaction is what? Is it over 100%? Is it 95%? What is it? I don't know, 83 and 76%, because it's two different parts of the contract that can be bad. But if, let's just say for the sake of argument, that 90% of those contracts were bad, that means if everybody had been attacking that contract, out of 10 million foreclosures, there would only have been 9 million people would have kept their homes.
Right. So it tells me that the lawyers were part of the problem by preying on these people who were coming to them for help. And I find that very disturbing. And going back to Mark Stopa, I'm looking at the article here, and it says that he's probably not going to appeal. He's going to accept the suspension, and he's going to start a company to help homeowners facing foreclosure, a company called Shining Armor, that would help borrowers negotiate short pays. Well, wait a minute. How can he help a company How can he start a company to help homeowners facing foreclosure if he's no longer an attorney? And who would actually go to him? But the scary part, is people will, because they won't have done their due diligence.
The scary part of it is all these Facebook groups that are allegedly helping homeowners but are only giving homeowners a place to whine. We've made comments about Stopa, and people are coming back saying, oh, this guy has saved thousands of people their homes, when in fact he saved nobody's home.
And that's right.
Useful idiots of these scammers and these stall attorneys spreading lies and misinformation, and it gets propagated throughout the public, and it brings the downfall of all these homeowners.
Let me point something out here. I'm looking at an article on the web from a lawyer's website. He shows a map of the United States with hot spots of foreclosure. Some out on the West Coast, some down around Houston, and a whole bunch in Florida. and stretching up the East Coast, plus some around Chicago, Indianapolis, and Detroit. But it's really red. They say that in this article, foreclosures are up 35% in Florida. Our foreclosure rate is going up higher. And where do you think all of these borrowers are going to go to get help with their foreclosures? They're going to go to law firms like, the one that's advertising this particular fact. What alternatives can we provide to them?
Well, you're doing your thing, Bob. I mean, with your Living Life the Truth and exposing the fraud. We're trying here, Storm and I, to expose the fraud, and we share this after it's aired. We share the podcast to try to help people. Now, Bob, years ago, you and I did a show, a different consumer advocacy show. You did it on suing lawyers and judges. It was like my number one show of all time, by the way, as far as hits and people listening. Well, listen to this. So recently I called the Florida bar asking them if they would like to do a show on what can consumers do or homeowners do if they feel they've been ripped off in some way by their attorney. And so, I got their public information officer who didn't call me back, looked me up online, found my email, copied me to 5 other attorneys, and said, sorry, we don't have anybody to do a show. But they copied and pasted from their attorney assistance, the ACAP program. They copied and pasted it to me, and I replied back to all of them, and I said, wait, you mean you don't want a free hour to talk about how you can help these people that have been ripped off, what they can do? There was never a response, and that to me said a lot. If the Florida bar is not willing to help people, they're not willing to make public, they're not willing to do a show, listen, they'll put up that attorneys that have done what I consider anyway criminal things or alleged criminal things, they'll say that they're a member in good standing because they paid their dues. But when you scroll down and you see their disciplinary action and you go, wow, they kept the escrow money from their client. I mean, to me, that sounds like a criminal thing. Slap on the wrist for them. Nothing happens in Florida unless you've got hundreds or thousands of people complaining about these attorneys doing what they're doing.
Well, Laurie, that's the problem. That's the problem.
Yeah, we got about 2 minutes.
Nobody is complaining because the lawyers the scammers and the lawyers inoculate homeowners. They tell homeowners, look, the judges are in the bank's pocket, and you're not going to win because the judges are in the bank's pocket. Now, when these homeowners go to court making these stupid arguments that these scammers have told them to make, or the bank takes the home from the homeowner when an attorney's representing them, they come back, and what does the attorney say to them? The attorney says, oh, hey, look, I kept you in your house for 3 years. What are you complaining about? Well, I'm the homeowner. I'm saying, well, wait a minute. You never told me all you were going to do was stall.
Right.
I never told you that. You need to read your retainer agreement. So that's the problem. So what happens is the homeowner never goes to the bar and files a complaint. What they do is blame the court system.
The whole thing is, to me, it was one big mess, and we've got to kind of wrap it up, guys. So I want to thank Bob Hurt. You have the Mortgage Attack blog, livinglivesthetruth.com, correct, for your website.
Yep.
Anyone listening can also contact us on Fraudsters Radio Facebook page. You can reach Storm directly through mortgagefraudexaminers.com. I think the whole situation is a mess. I think they were put into a mess by the attorneys, adding insult to injury to an already bad situation. And that's what we're trying to expose on this show. So we do love callers, and we want to thank that fellow Frank who called in earlier. And I want to sign off today by thanking everyone for listening to us. Please join us again next Monday from 1 to 2 p.m. Eastern live. And remember, we do want to hear your stories. Again, you can contact us through the Fraudsters Radio Facebook page. Thank you, guys.
Bob, we appreciate you coming on. We appreciate your expertise and commentary, and thank you for what you're doing to help them.
Glad to do it.
Okay, guys, signing off. Enjoy your day.